Good afternoon, everyone. My name is Andrea McAvoy. I'm the Director of Client Services for IPIRA's Office of Intellectual Property and Industry Research Alliances. We appreciate you joining us for today's session, Talking Tech Transfer, Patenting and Licensing IP Fundamentals. Other IPIRA webinars being offered this spring include Industry Research Funding, Partnership Fundamentals on March 12th, How to Start an Industry Consortium Program on March 19th, and SBIR STTR grant funding, small business research subcontracts on April 16th. Our marketing communications director, Deborah Summers, is currently sharing registration links and additional details in the chat. And keep an eye on your inbox. Deborah will be sending a follow-up email containing many of the resources mentioned today. If you are a UC Berkeley faculty member preparing for promotion or tenure conversation, you may be interested in registering for requesting IPIRA's new Innovation and Entrepreneurship Activities Report. It provides information on faculty I&E activities tracked by our peer divisions, the Office of Technology License and Industry Alliances Office. Today's featured speaker is Laleh Shayesteh, IPIRA's Director of Intellectual Property and Administration. Joining her is Eric Geigerich, the Director of our Industry Alliances Office. We want this to be an interactive conversation, so please feel free to unmute yourself to speak or drop your questions into the chat at any time. Please note that we are recording the session for the IPIRA YouTube channel. If you have a specific inquiry or sensitive topic that requires confidentiality, please wait to ask Laleh upon the conclusion of the recording. A quick survey will be popping up at the end of the meeting. We value your input as it helps us curate future webinar series. To kick things off, I'm going to launch a poll. Your participation helps us understand who's in the room, as well as how we can best support your engagement. So let me do that now. We'll give it another second or two. All right, well, I think we'll end it now. All right, thank you for those responses. Laleh, I'll hand it over to you now to start.
Thank you. Hi, everyone. Thank you so much for being here today. I tend to give my talks without PowerPoints because I would really like it to be interactive, and IP being one of the most boring topics on the face of this earth. Really, I don't want to make any of you get into a coma. So it would really be helpful and fun, actually, if you bring in your questions, either ask them as we're going on or drop them into the chat as I'm talking. I'm a fast speaker, so this conversation can be about 5 minutes or it can take the whole hour depending on your interaction. So let's jump into it. I work at the Berkeley IPIRA, as noted, in Intellectual Property and Industry Research Alliances. We are into translating groundbreaking research for economic and social impact. The social part is really, really important to us as well. We are two sister offices. I work at the Office of Technology Licensing, where we take disclosures, we ask of intellectual property, and we try to license them out. And we take all sorts of random questions about IP from anyone and everyone around the campus. Our colleagues our sister office, the Industry Alliances office, is being represented by my colleague Eric Geiger, where they bring in money from industry, from commercial sources. We work really well with each other to try and make sure that we are providing the very best service to all of our campus communities. So we always want you to ask any questions you have from us, and we are always happy to help out. So the talk conversation today is about intellectual property and tech transfer. So first of all, what is IP or intellectual property, right? So as far as I'm concerned, and as I've always said it, it's what's in between the two ears, right? And we are so fortunate to have at UC from all of you, right? It's scientific and technical information. It's data, designs, processes, procedures, materials, compounds, recombinant sequences, new methods, software programs, works of authorships, and what's really near and dear to my heart, inventions. So there are different types of IP protection, and I'm going to call intellectual property IP from here on out in case you keep hearing IP. There are different ways of protecting intellectual property. So I'll get rid of the very first one because we usually don't have it at UC. The first type are trade secrets or know-how. Let me see. Can any of you give me an example of a trade secret? Come on, we have a lot of people here. Somebody should tell me something or type in. There you go. Excellent. That's correct. So beautiful. That's exactly correct. So trade secrets, well, let's say Coca-Cola is a lot better than Coke, but okay. Exactly right. So trade secrets are what a company, a commercial company, keeps to itself. Doesn't let anybody else, outside. So and only a very select group of individuals might know that secret, right? That secret recipe. The good thing about it is that nobody else will ever know what it is. The bad thing about it is it's really not very well protectable because, for example, since so many of you brought up Coca-Cola or KFC recipe, right? So Pepsi-Cola created something very similar, right? And Coca-Cola could not stop them. So that I don't know a lot of the chicken chains, but there you go. Some other chicken chain can pops up, and KFC cannot stop them from commercializing their stuff. So trade secrets are one kind. And at UC, we don't have trade secrets. Why? Because we are not a commercial entity. And two, because we publish everything. It's our job. We are a public educational institution. We publish. So no trade secrets for UC. Also, know-how. The next kind of IP is know-how. And know-how, again, is, let's say, formulas or knowledge that is only known to you, but not to anybody outside. And again, know-how is not something that we keep because we publish everything. A lot of times entities from outside come along and are interested in working with us, and they say, hey, license us your know-how. And the answer is always no, because we don't have know-how. However, if I'm really pushed and our investigators are really interested, I'll say, okay, um, I'll give I'll give you know-how as long as the investigator is willing to write down what that know-how is, right? So they write it down, we package it up, we give it to you, and it will never be exclusive. It will be non-exclusive because we're going to be publishing it ourselves. I'm getting a question, is proprietary LLM a trade secret? That depends on how you want to keep it. If you want to keep it as that trade secret for forever, it could be your trade secret for your company. Um, Again, at UC, we are not going to keep things proprietary. The other type of IP that we deal with are copyrights. So copyrights protect expressions. They don't protect ideas. And what are various types of copyrights? Various types of copyrights are software. They're all the publications you produce. They are let's see, and not the university world, they're dances, they're lyrics. All of those are protectable by copyrights. The next type of IP are trademarks. Trademarks protect brands. Can somebody throw me a trademark that you may know of? Good job. Good job. That's right. Nobody said UC Berkeley. Huh, there you go, Art. There you go. That's right. Those are trademarks. Trademarks protect the commercial interest of a brand, right? And for example, Berkeley really furiously protects the name of Berkeley or Cal or UC Berkeley because we don't want other entrants, we don't want another entity to name themselves the same and confuse the marketplace with the name, right? Finally, well, not finally, one more. Another means of protecting IP are patents, and patents protect inventions. And I will go into that because that's most of what I'd be talking about before we go into licensing. And finally, another means of protecting intellectual property are agreements. And what do I mean by that? Let's say that as an investigator, you want to do something, you want to create a piece of intellectual property. However, in order for you to be able to complete that piece, right, you need to speak with somebody else, right? You need to speak with another investigator at another university or perhaps at a company. You need to work together to bring it to create that invention. However, you don't want to just talk with them and publish, provide them with your confidential information for no reason, and neither do they. And in those cases, we enter into what are known, for example, as confidential disclosure agreements or non-confidentiality agreements or non-disclosure agreements. They have various names, same idea, meaning that you will enter into an agreement with your friend to say, or your investigator, your collaborator, that we are going to be working on this one together and we will keep the information confidential between us until, right, that we have either filed an application, we have filed for a grant application, or we have actually done a disclosure or done patenting together until the invention. I always call it half-baked to baked, right? If it's half-baked, you work together to make it complete and then send it in. And so those are agreements. Now, let me stop here. Do I have any questions to now? No. Yes? No? Okay. Then let's go into patents because that's the most interesting type of IP along with software that UC works with, right? So how many of you remember when you enter as an employee of Berkeley, as a professor, as a PhD student, as a general employee like myself, that you signed a patent acknowledgement when you entered Berkeley? None of you. Meh. Okay. So, Joy remembers. Awesome. Thank you. So, thank you. Basically, all of the employees of the university, when we entered into the doors, we all signed a patent acknowledgement agreement that said, if I use any university resources, because I'm an employee, because I'm receiving money from the university, if I use any university resources, grants that are being administered through the university, and I'm creating intellectual property during my time at university, it will belong to the university. The exception to that is for the professors out there, your lecture material, your course material belong to you. UC does not take ownership of that. If any of you out there are undergrad students or master's students where you are paying your own way to be in the university and you are not using any specific university resources or you're not using any grants that are being administered through the university, the IP will belong to yourself. UC does not ask for that intellectual property. So this sets the stage for then everything else that will belong to the university. All right. Ah. Okay, Sanjit is asking, this is a really good question. This is so if I want to start a company with software technology I developed at Berkeley, which are open source at this point, can I start a company right away? Is the process. Okay. If it was open sourced through Berkeley, remembering that that software still belongs to Berkeley because it was used using UC resources, time, everything. Um, we are not going to ask you to give us anything because it's already open source. Let's say under a BSD license, under an Apache license, you have gone to the other side, you are starting a company, no problem. But if your company becomes successful, you might get a knock at your door with us, right? Hello, you know, you did use UC time resources to develop this. Let's talk, right? One of the instruments that we are providing very recently, actually two instruments that we are providing very recently are number one, an OS3 agreement. So that is very specific for software. That is open source software good standing agreement. If you're starting a company using software that you developed at Berkeley using Berkeley Time Resources funding, open sourced it, went to the other side, we will sign an agreement together that will say UC agrees to let go of this software for you if you promise to give us royalty and participation rights in your company. That's one instrument. The other one, especially if the company wants to be a little more free to use more than just the software and IP that is not necessarily patented or copyrighted, we have also developed an IAA. Thank you, Eric. or which is a brand new agreement that we have that also allows you not only to use the Berkeley, for example, the software that you're developing, but also perhaps using UC's trademarks in exchange or attaching yourself to UC, saying, I developed this through UC. And again, providing a participation right to the university. I hope I'm answering you, Sanjit. But nothing is stopping you to start your company. Go ahead, multiply, have fun. I have Ellie, who's asked L. Does UC own anything I develop under contract industry? If you are a UC employee, any contract you will have with industry that does not predate the UC agreement is subject to your agreement with UC. So if I don't know, and I have no idea what you're doing with the with industry, but I'll be more than happy to speak with you later if you like, to answer you a little bit better because I'm not 100% sure that you may want to discuss more about your employment or contract with industry right now. Okay. So as far as patents are concerned, for those of you interested or in the business of creating intellectual property in the form of inventions, what can be patented actually? Anything, as far as the Supreme Court is concerned, anything under the sun modified by a human that is novel, like nobody has done it before. It needs to be non-obvious. So the pieces exist, but nobody has put them the way you have put them together before, and it needs to be useful. So for example, if you're in the biological arts, you cannot create a new mouse to just so you can feed it to a lion. That doesn't work. That's not useful use of a mouse. However, if you create a mouse to treat Duchenne muscular dystrophy, good to go. That can be patentable. And at the same time, an invention needs to teach somebody skilled in the art. Skilled in the art means somebody just like yourself who will understand what you're saying on how to make and use your invention. And in exchange for that, the patent office is willing to give you a patent for your invention in exchange for 20-year exclusivity for you to stop others from making, using, or selling your invention. All right. Um, it, so at UC, how do we look at patents and what do we do when we receive invention disclosures? Um, Personally, I've always said, and our office treats it this way, our barriers for filing a very first application on an invention is really, really low. I'm always happy to file a patent application, a first patent application. However, the reason we file patent applications and the ultimate goal for the university on filing patent applications is not to get a patent in your name. It is to receive commercial interest in the technology. So if before the end of the first year after that patent application has been filed, we have not received any commercial interest, it'll be a little bit more difficult to press us to go to the next stage of the filing. Patent applications in general, from the time that we file the very first application to the time that we will get an issued patent, depending on the industries, can be anywhere between $50,000 to $100,000. So for something in biology, for an invention in biological or chemical arts, at least $100,000 for just the US patent. If we want to go anywhere outside US, imagine for every country, it's going to be about the same. For instruments or perhaps mechanical arts, it will be about $50,000. So we think really, really carefully before we want to file or continue on filing applications or continuing with prosecution of an application, unless we receive commercial interest. Most hopefully, someone from your own labs is interested in starting a startup, and we would love to start working with startups and helping them grow. Um, and as far as patents are concerned, right, different industries have different ways of um, working with patent applications, and we do the same. So, for example, any patent application that comes in or invention that comes in for example, pharmaceuticals or chemicals, the objective of those patents and applications, especially from partners, be it a startup or be it pharma, for example, is monopoly. Therefore, they really enjoy filing blocking patents all over the world, right? However, if we're talking about applications that are related, most notably and most sexy these days, AI or software, internet, the objective is just leverage so that when competitors are walking all over your patents to create their products, you can stop them from doing that. And so we look mostly, and our licensees look mostly at where that patent application or patent will give them the most bang for their buck, to say the least, right? And usually, then for those types of applications, we only enter into the U.S. and perhaps one more jurisdiction if we have to. All right. Somebody has asked me if the inventors have to give us a prior art search or patent search before contacting our office. Absolutely not. We don't want them from our inventors, and we will not do them ourselves either. Our office has maintained a distinct policy or practice that we don't want to do prior art searches. And my belief has always been that if you're at the bleeding edge of your own science, you don't need to do prior art search. You already know who else is doing what. And also that once we file this application, if it makes it to the patent office will do that prior art search for you. We'll give you the results. We will deal with that. We don't do art searches at all. Also, because I've been doing this for 20, 30 years now, there is no way on the face of this earth that you will be able to dig up all the art that's out there that might read, all the art, all the publications that are out there that might read on your invention. Why? Because for a year and a half, for 1 year and a half, that's right. For a year and a half, any invention that we file on or somebody else has filed on will be in confidence, will not be disclosed to the rest of the world. So if you're doing a search right now, you'll be missing anything that might have been filed in the year and a half before as a patent application. So it's a lost cause as far as I'm concerned. So we don't do prior art searches. All right. And then what happens once we file these patent applications or we receive invention disclosures? One of the first things that we do is we create what are known as, like I said, because we want to gain commercial interest in these technologies, one of the very first things we do is we create, or Andrea nowadays will create for us, what are known as non-confidential disclosures. We will create a disclosure based on your invention disclosure or patent applications that we have, or patent application that we have just filed. And we will put them on our available technologies website so the whole world can see. UC is 10 campuses. Every campus does that. And so all of the available technologies get ported to Office of the President. So UCOP has a site that covers all of the technologies from all the universities, including Berkeley. So the whole world can see what we have as an available technology. If they're interested, they can approach, it has the inventor name, and it also has a name of a person like me or 5 others who are just like me in the office to reach out to in case there's an interest from industry. I can say that thank you, Deborah, most of the time, the interest comes from connections that the investigators have themselves with their commercial partners. Under agreements that we have with commercial partners, a lot of times we are supposed to give them an option to negotiate a license with us if they want to pay us money so that we can actually file and prosecute the patent applications. Or the lab might be interested in doing a startup. Somebody from the lab, maybe a postdoc, maybe a graduate student, is now interested to start a startup and the professor is interested to be a founder. That's fantastic. That's the best outcome usually. We really like that. All right. And then once we have interest from a commercial interest in the technology, we then launch into technology transfer. So what technologies are we talking about? We talk about inventions that we have been talking about to now, software, and these will be probably software, most likely software that we have not produced as open source, software that we have kept in-house at Berkeley, or software where we have open sourced, but under a very specific open source license that says, and it's actually a riff on the BSD license that says, hey, if you are using this software, want to use this software for non-commercial purposes, have at it, have fun. But if you want to use this software for commercial purposes, reach out to Office of Technology Licensing. So then we will negotiate a license on the software with the entity. Or nowadays, what is becoming very popular is negotiating licenses about data. We are not a medical school, so we don't have as many data licenses as medical schools do, but data is definitely of interest nowadays. And then what happens if somebody is approaching us for a license? The very first thing we do is we make sure that our biggest source of funding, hopefully, that we're looking at the intellectual property and making sure that we are meeting all the requirements under the agreement that we have had that created the intellectual property. We are meeting all those requirements before we license it out to anybody else. And what do I mean by that? So the biggest source of our UC funding is still from the federal government. So under federal government, each time they give us a grant, each time they give any university a grant, if IP is created, if intellectual property is created, the government takes a non-exclusive license to that intellectual property. We need to make sure the government gets its license. If we have been working with foundations, we need to make sure foundation knows that we have now created intellectual property. If you're working with commercial partners, we need to make sure we immediately report the intellectual property to the commercial partner in case they're interested in that piece of intellectual property. And then, subject to all of those, then we will have to see what we have left and whether we are able to now license that intellectual property either exclusively or non-exclusively to a lot of different entities and or either license it or basically not license it at all. So because we have now had so many requirements to meet with our other partners. And and then let's say now that somebody has approached us for an agreement and we, to give them a license, and we do have the ability to give them a license. What do we do then? We have different types of agreements actually that we enter into, and depending on the stage of the company and the stage and the amount of their interest, we enter into these different types of agreements. Remembering that any agreement that any intellectual property that comes out of the university is very, very, very early stage. Any entity that gets interested in the intellectual property is going to either work with the lab, continue to work with the lab to bring it into, to de-risk the invention, or take it into their own space. The startup, for example, a startup might want to take it into their own space to de-risk it before they want to launch into a complete license. So with that, then we have different types of agreements. The first agreement that we usually like to offer, I like to offer, especially if we have a startup or an entity who is interested in the technology, but they don't know what they want to do or how fast they want to enter into the license or whether it's even going to work in their hands. We enter into what are known as letter agreements. Very simple agreements. One-page document that says, UC will promise you to have this agreement, to have this technology. You can work on this technology in-house. You cannot sub-license it. You cannot give it to anybody else. You can work on it in-house to see if it works in your hands. The term of the agreement can be anywhere between 6 months, probably a year. If you can push me a lot and pay me more, maybe a little longer. Uh, but for a very small amount of money, probably for a portion of what we paid for filing the application, the related patent applications, right? The next type of agreement, especially if the entity who wants to work with us is a very big company and they're usually very worried about one-page agreements, we will enter into what are known as option agreements. It's a 25-page letter agreement. It says the exact same thing. It's just 25 pages long because it says, here are what we will agree to talk about in the future. Option agreement. The term is a little bit longer, and we do expect a basic commercialization plan for the technology. What are you going to do with this technology in the next year or year and a half? We want that. And the last type of agreement, which is, uh, the most worked on type of agreement and the most of the most interest because it allows the company to make, use, sell the technology is a license agreement. For a license agreement, we will need a commercialization plan. We want to know how the company is going to bring the technology to a commercial stage. And there are, payments, all the patent costs need to be made, and a whole bunch of fees and ultimately royalties, sub-licenses. When a company that approaches us is very small, let's say a startup, we are very easy on them in the beginning. So entering into an agreement with us will be easy, but we will take a bite out of the company, meaning that we would like to have equity in the company, and also take larger royalties. And why is that? It's because we want to be successful if the company is successful. If a company that's approaching us for a license is already a very well established and a very large company, then we charge them for license, for licenses, we charge them normal commercial fees for everything commercial because because they're already successful. And what we want are much, much larger license initiation fees, still payment of all patent costs, and then definitely no equity, but yes on royalties. All right. And at this point, I'm gonna stop. So now it's your turn to ask me any questions you may have. I'm done with um, my conversation. Let's see, Amir. Are patents invention disclosure requests attended to on a first come first served basis or always on a first come first served basis? So all invention disclosures come in. So we don't receive patents, we receive invention disclosures. Invention disclosures are done online. And once an invention disclosure has started, all of people like me, so there's five of me in the office, six, yeah. All five of us receive the same invention disclosure, that we receive a notification that the invention disclosure has started. And when the invention disclosure finishes, all five of us receive the same. This invention disclosure has been submitted. So based on our prior working relationship with our inventors, if we have had any, the person who has had the most interaction with that inventor will be picking up that invention disclosure. If you have not had any interaction, we look at it and oh, this is fun. I'll take this one, unless anybody else has an objection. So one of us will pick that invention disclosure. The invention disclosure gets docketed, and once it is docketed, then we will contact the inventor. We will have a chat with them, or inventors. We will have a chat with them, and we will likely start the process of filing an application, a first application. All right. I have a question. What is the mix of different agreements that go through your office? Vast majority letter with license agreements being relatively more uncommon. Actually, let me think. Yes, the first agreement is always a letter agreement, but we do want a license agreement at the end, right? Everybody wants a license agreement at the end because otherwise, why are we doing all this patenting? I can very, very proudly say that out of and among all the other universities, we are a very rare breed. We receive 80% interest, commercial interest on our technologies, meaning that we actually do license and receive money, 80% of what we spend back in the form of licensing revenue. And then when the licenses are really successful, then we receive a lot more. And when money comes in, 33% of when net revenue comes in after all patent costs have been paid, 33% of the net revenue gets divided in between the inventors. 15 at Berkeley, 15% goes to the department of the inventors, and the rest of the money goes back to the university for research and education. If an invention is successful, or if a technology is successful, it bodes really well for the university, brings a lot of money back for the university, and we're very proud of that. We have done well for the university. Okay. All right. Any other questions? Don't be shy. Do you have any cautionary tales that has not been disclosed but should have been disclosed? Well, very much so. So I do have a lot of times when an invention disclosure comes in long after the disclosure has happened. So the disclosure comes in, and one of the questions is, have you actually disclosed this to anybody outside of UC? Oh, yes, I gave a talk on this one at such and such time and another abstract at such and such time, and now somebody told me this is really important. I should patent it. Here you go. And so the answer to that is a very hard no. We will not be patenting that. Any publication that happens on an invention makes the invention unpatentable in the rest of the world. In the US, we still have 1 year of grace period to file an application on that invention. However, US is like the rest of the world where we are a first to file country. It used to be a very long time ago, it used to be a first to invent country, but now I think as of 2013 or 2015, a first to file country. So if within the year, let's say that I went out, I gave a talk on my invention, somebody else was in the audience and they um, thought, oh, this is interesting. And they added a couple of different variations to my invention and they filed an invention. And then we have filed an invention. We, as a university, don't want to go to fight with them to see who invented first. We just don't want to. So if you have already published or disclosed to your invention to those outside of the university, as far as the university is concerned, we are not going to be filing on it anymore. We also have had a lot of times that an invention has not been disclosed but should have been, which is fine. That just means that we completely lose any commercial interest or ability to commercialize the technology, right? All right. Thank you, Eric. My second guess was correct, 2013. All right. From you see that an investor can search through. So that would be, we don't provide our invention disclosures because invention disclosures are confidential subject matter of the university. And even if we file an application on them, an application as far as the US is concerned, or the world is concerned, is going to be confidential for 1.5 years, unless a paper has been published on it, which is perfectly fine. But that database is the non-confidential disclosure of available technologies that I just talked about a little while ago. So we put non-confidential disclosures of what is available at UC Berkeley for all of our inventions. Any entity is more than welcome to take a look at them. Okay, what percentage does UC take from an inventor founded startup? That's a really good question. It depends on the startup. It depends on the same equity so let me back up. One of the things that we do is we try to provide the same terms to any startup that comes out of our university that are similar or the same as the same or similar technologies that have come out of other universities around US. So if, for example, a technology is let's say a drug, right? And that same or similar drug for cystic fibrosis, right? And that drug for cystic fibrosis out of any university in the past 5 years that has come out, similar drugs for cystic fibrosis that have gone into startups, and the university has taken a 3% stake up to, let's say, $8 million or $10 million anti-diluted, we will ask for the same. We don't ask. We try sometimes to ask for more, but we don't. We really try to be fair. So if it is a mechanical subject matter, right? If it's something mechanical, and the best that any university has been able to get is 1% up to $2 million non-dilutive, that would be the same we would be asking. So it depends on the technology. It depends on the startup. There is no specific number that we go for. All right. Do other UC affiliates have similar databases. Do you mean other UC campuses? Yes, all 10 UC campuses have the same database, and all of the inventions that are provided as non-confidential disclosures get ported up to the UCOP site for available technologies for all of UC. Oh, thank you. All right. Okay. Have I answered everything that came through? Okay. Any other questions? No. Okay. All right. How do we know if the research reached the stage of being ready for patenting? We almost never do we? So we are a university. Our job is to publish, right? And for any of you who are out there who are investigators at a university, it's publish or perish, right? That comes with the territory. Therefore, the best time to file an application, I always say, please reach out to us early and often. Please reach out to me early and often. Yeah, I cannot say that enough times. And talk with us, right? But if you don't want to do that, right, you're always more than welcome to send in an invention disclosure because we will reach out to you and we will talk. The best time to file a patent application is number one, right before when you have a document of what your invention is, and the document is pretty good. For example, let's say it's a grant application. Let's say it's a almost ready publication. Or if it is software or AI related, it's a really good flow chart. Really good flow chart because that's the only way I'll be able to put a patent behind that one. I'm serious. because because software by itself is not really patentable. But if I have a really good flow chart of what the algorithm is, no problem. I can do it. So the best time is before the darn it thing is published, before you're about to put it on, send it in for a publication or send it in for a grant application. A grant application, as far as the Patent and Trademark Office is concerned, is supposed to be confidential subject matter. However, in my prior lives, I can tell you that I had seen, we would provide white papers or suggestions to some of the parts of the government, and all of a sudden, the next thing we knew, that almost identical to what we had suggested came out as a request for proposals. So, and that's as of a lot of years ago. I'm asking people, if you're ready to send in your grant application, let us know. We will be happy to file a patent application for you. So it's not I cannot tell you when the very best time is to file an application, but it is definitely before a publication. And if you're sending your darn it thing or your publication through a bioarchive, don't come to me. Then to file a patent application, it's already been published. All right. Interactions of VCs investing in startups and licensing practices. Well, VCs do like to see. Okay, let me back up. There's a lot of reality and a lot of stories regarding VCs and interaction with licensing practices, right? The best interactions come when VCs engage with us, when they know exactly what it is we're doing, and they understand that UC is actually putting its own skin in the game, right? We are filing the patent applications. We are putting a lot of money into prosecuting these applications with the hope, right? And university as a whole, right? The investigators have used university time, resources to create these inventions. And now that a startup is happening, UC is agreeing to charge them really little in the beginning in exchange for happiness at the end for both of us, right? Success at the end for both of us. We have a lot of VCs that are completely on board with this arrangement. In addition, I'm really proud to say, and Eric is here to help out, right? that we have at least 6 or 7 internal facing funds right now that are interested in putting money into startups that are coming out of Berkeley. So um, VCs that know us, VCs that have worked with us are always happy to work with us more. Actually, nowadays we are receiving a lot of interest from VCs who want to, and again, this is what Eric's forte is, VCs that are interested in creating spin-outs, startups that will be created specifically out of experiments and work to be done at UC Berkeley. Eric, you want to say two?
Yeah. Deborah, maybe could you get the venture capital link and put it in? So yeah, we're joining up venture capital sponsorship of venture capital funding with sponsorship of research. So think of a venture capital entity funding your research instead of a federal lab, federal agency. And then what does the VC get at the end? They reserve rights for the IP. They create a new co. That new co licenses the IP from Laleh's office, and then they're off and running.
Perfect. Thank you. Yes. So, Amir, I'm hoping I answered your question. All right. Any other questions? No. Yes. Keenan? Yes.
Yeah, so I understand that right now NIH has paused the SBIR STTR program. Have you guys heard whether there's any likelihood of that? I mean, I know that we have so much uncertainty, but have you guys heard of anything about like is that coming back soon? What's the deal there?
I keep hearing that it is going to be discussed soon, but whether it's coming back immediately or soon, we don't know. And that is, it's not a very good idea for the government to kill small businesses this way. But I shall shut up now. We love actually working with SBIRs. I'm sorry. Go ahead, Eric.
Oh, I will just say we have a workshop coming up with Kate Lewis in our office on SBIR and STTR grant funding. That's probably one of the big questions she's going to be asked, just like you just asked, Keenan.
Yeah. Awesome. All right. If there are no further questions, I'm not going to take any more of your time. But please feel free. You're always welcome to send a question either directly to me or through our IPIRA concierge. And our staff members, mostly Deborah, will always find one of the 5 of us to answer those questions. And we're always happy. We're trying really hard to respond within a day, which is awesome for a place as large as Berkeley. All right. Thank you, everyone. I really appreciate your time. Take
Well,
care.
thank you, Laleh. That was a really robust presentation. And
Awesome.
I also want to express my thanks to Deborah and Eric for putting in all those resources. If you weren't here from the beginning of the presentation, you will be receiving an email with many of the links and resources shared today, along with the recording of this webinar. I also want to just thank everyone who participated today and for your attending. Please do share your feedback on the survey that you'll see once you exit this webinar. As Laleh mentioned, don't hesitate to reach out to any of us. We're here to be a resource for you. And have a great afternoon. Thank you, everyone.
Thank you. Bye.
Bye.